Another question that's asked, usually as we get closer to trial, is whether a defendant should testify on their own behalf. There's always a lot of pitfalls when going on the stand. One of the issues is that as a defense attorney, I cannot protect you once you get onto a witness stand. And the prosecution has the ability to cross-examine you after I ask your questions. And so sometimes when a person is intimately involved with a case, being accused of a crime or being a defendant, it can read to the jury as arrogance or indifference because you are so upset with what's going on. And those types of traits and characteristics don't come across well in front of a jury. And so before you decide to testify on your own behalf, there would be a lot of discussions and conversations we would have. There are two rights that a defendant has that they get to choose on their own solely. One is whether they have a jury trial, and the other one is whether they testify. If you testify, the judge will not instruct the jury that your testimony or your remaining silent is not to be held against you. Once you decide to break your silence, you better be ready to close that case and make it happen. And that is a very hard thing to do for anyone, even if you're an experienced litigator or an experienced witness.